Yes. Mic, please, mic on.
Number submission, my lord. In view of urgency, bank officials may come up at any moment taking position under section 14 of Securitization Act.
Some fresh matter.
Yes, my lord.
When you have filed?
Tomorrow, my lord.
Have you filed?
Yes, and yesterday I filed.
Yesterday you have filed. It will in routine manner. When it will come?
Well,
Huh? 15th means which day? Tuesday.
Friday, Saturday and Sunday holidays, the bank official may come up. Residential house, school going children are there, my lord.
What is the urgency?
Urgency, the bank officials, they may come up, they are going to take physical position, my lord, under section 14 security. Already order has been passed by magistrate.
What can be done here? You know.
Writ appeal, is it?
Writ appeal.
A learned single judge says alternative remedy. Alternative remedy.
That is the correct view. We have already given 2 judgments.
I've taken 1.5 crore, my lord, residential law. I already paid 1 crore in the year 2016.
If you want,
3 crores.
All right, now you have filed it. We don't want to say anything. Let it come tomorrow.
Get this.
Number 1, I appear for the petition. Order of the revision authority. That the petition before the noxious penalty is company involved in the construction of the national highways. That for the petitioner is interested in the construction of the national highway, extraction of the national highway and Index 4. That in order to construct the national highway, the petitioner made an application for grant of quarry lease for sourcing the building stone, which is one of the raw material. The deputy director issued a notification notifying the grant of quarry lease. That as per the circular issued by the government at the time of
your revision has been rejected.
Yes.
Yes. Now, on what grounds you are telling?
He doesn't rely on the report of the deputy director, which has been submitted on the report of this honorable court. Your lordship, kindly see annexure U, page 258, value 1. It is because of the wrong fixation of the boundaries by the Department of Mines and Geology. So the encroachment has taken place. That is the report of the deputy director, annexure U.
That has not been considered.
He says, that is not binding on him.
All right, all right. We will grant you time.
May I read 2 paragraphs?
Now, after revision, let your statement of objection be filed. We will decide it finally.
Please.
The learned AGA shall accept notice for respondents. Copy of writ petitions for the respondent shall be handed over to learned AGA. Learned AGA prays for is allowed 4 weeks time to file the statement of objections.
Interim order,
no interim order.
I had the benefit of interim order.
After rejection of
annexure A, if your lordship could see annexure U,
merely because one document has not been considered, it will not lead to any patent illegality. So
he relies on the report of the Assistant Director Land Records, which has been rejected by the state government. After rejecting the Deputy Director Land Records was appointed as to survey the land.
It is contrary to the direction issued by this honorable court. That is
whether you were having any interim order during
annexure A, throughout this honorable court protected my interest.
This honorable court, we are not asking whether during revision, pendency of revision, you were having any interim order.
There is a circular issued by the government, once the revision is filed, there is an automatic stay granted.
That
interim order.
We don't understand that.
The joint director directs recover this money. 7 crore 84 lakhs, which we have used it for.
We can fix it at early date. We'll fix it after 2 weeks. You take 2 weeks.
AB is the interim order.
It has to be finally decided. Nothing. No interim order. You file a statement of objection within 2 weeks. List thereafter.
Please,
Give a short date.
Clear.
Please.
उसके बाद तो खाली हो गया रिवीजन में गया तो कहाँ शुरू हुआ?
Number 2, issue number. I am appealing for the appellant in this case. Appellant, your lordship, are the tenants under the State Bank of India. A proceedings under section 4, subclause 1, Public Premises Act was initiated against the petitioner. The state officer has passed an order of eviction against which appeal came to be filed before the district court. Now, the learned district judge, my lord, was pleased to allow the appeal and remanded the matter to the state officer on the ground that the notice issued by the authority is bad in law, against which the writ petition came to be
What
filed.
has been done?
Pardon.
Public Premises Act, District Court Appellate Authority.
The learned single judge was pleased to allow the writ petition. My lord, without going to the merits, my lord, admittedly, my lord, we are in occupation of the premises for the last 7 years. Some time, my lord, the learned
No,
single
the
judge
building belongs to whom?
belongs to State Bank of India. Earlier, it was with the State Bank of Mysore. After the merger, my lord, it belongs to State Bank of India. We are not disputing that.
Your appeal has been dismissed.
Pardon me.
In the appeal, matter was remanded.
In the appeal, my lord, learned single judge was pleased, learned district court was pleased to remand the matter, against which the writ petition came to be filed. Now the learned single judge was pleased to allow the writ petition, my lord, and granted 3 months time to vacate
On what basis matter was remanded?
on the basis, my lord, notice issued by the state officer is bad in law. Now, only on that ground.
Notice
and
issued?
with notice issued by the state officer is bad in law. Now, my lord, it was, in fact, it was considered by the advocate appearing for the bank. May I take your lordship attention to page number 150, my lord, 150, where, my lord, the advocate appearing for the bank has considered that notice is bad in law. Therefore, considering all these factors, my lord, the district judge was pleased to allow the appeal and thereafter remanded the matter. Against the order of remand, my lord, writ petition came to be filed. Now, learned single judge was pleased to allow the writ petition, my lord, and granted only 3 months time, my lord. My only request, my lord, some reasonable time. We are in occupation of the premises for a long period, my lord. At least to such alternate premises.
Who appeared for the other side?
Other side, my lord, before the learned single judge,
Who is the counsel for the bank?
Amish Hegde, HS. One Amish Hegde.
Amish
appeared.
Hegde.
Yes, my lord.
So if you can bring him here, with the consent, we can extend the time. We'll extend it to 6 months if both parties agree.
We cannot agree, my
Eh?
lord. And,
So we will make them agree.
yes,
Call them.
1 year.
Don't tell him that what for we have called him. Say that court has called you.
Brother,
You call him here. Let's see. We will ask him to be reasonable, and
my lord, may I request your lordship to have this matter?
because only thing that you want some more time.
Some more time, my lord.
All right.
And moreover, my lord, now
You
last paragraph, your lordship kindly see.
he must be your friend. Ask him to please come here.
It is because we'll have to search, my lord. Some more time may be granted, my lord.
So then,
That
if you bring him here today, we will pass the order. If you can bring him here today, go and call him. Call him. Tell that court is calling. He will immediately come.
may
We'll pass it over. You
16, whether he has come to the court or not,
I don't know.
What can we do?
I have this matter 16. I will, on that day, I will get him. I will get him on 16.
We will not issue any notice.
No, I will inform him. I will
Direct his name to be shown and post it on.
Try find out first. We will pass it over today. We will take up in the revise.
Yes,
If he is present, then it would be better.
yes, yes.
Otherwise,
I will try.
how can we on our own extend the time without his?
I will try. I will try.
Abhishek Hegde. Just check from the directory.
I will.
Advocates directory.
I will.
Pass over.
Yes.
Same.
Lord, this is also connected to serial number 2. Same order.
All right.
Number 4. Now the plaintiff's suit has been dismissed by the court below on the basis of an Order 7 Rule 11 application filed by the respondent, stating that the
Sometime you appear virtually, sometime you appear physically. In which cases you appear physically, in which cases you virtually.
my lord, I apologize, my lord. I mostly appear physically. Yesterday there was an inconvenience, which is why I appeared virtually, my lord.
All right, all right. Yes. It was on lighter side. Yes, what is the matter?
My lord, an Order 7 Rule 11 application was filed on the basis that the suit is barred by Section 69(2) of the Partnership Act. Now, it's my humble submission that both the partners of the unregistered firm are also plaintiffs before the trial court below. So, the bar of 692 would not arise, since it is settled law that though a unregistered partnership firm can't file a suit in its name, if all the partners are made plaintiffs, then such a
Just a minute. Just from the beginning, you just tell us the facts, how this appeal has come up before us.
This is a suit that was filed by an unregistered partnership and its partners seeking for payment of money. It's a suit for damages. There were certain services that were rendered to the defendant. Defendant accepted services, made part payment, then subsequently turned around and said, I will not be making any further payment. As a result of which, all the plaintiffs came before the trial court and filed a suit asking for payment of those monies. Now, when the plaint was filed, the defendant entered appearance and filed an Order 7 Rule 11 application, stating that the first plaintiff is an unregistered partnership firm, hence it is barred by Section 69(2) of the Partnership Act. It was our contention, the appellant's contention, that all the partners of the unregistered partnership firm are also before the trial court below. Hence, the bar under 69(2) would not be applicable, since they are also parties and they also have a right. That is the short gist of the matter before this honorable court.
That Order 7 Rule 11 has been allowed.
It has been allowed, my lord.
You have come against that.
Yes, my lord. Impugned order, my lord.
What is the legal position in case the partners are also party?
Yes, my lord.
Whether the Section 69 would be attracted or not?
It would not be attracted, my lord. In fact, there is a judgment of this honorable court itself.
You have to issue notice. Correct. We'll issue notice. All right. You've seen the order. It is issue notice to respondent. You take the hand notice. In addition to the regular mode, the appellant may take hand notice. Give it next week. You file after service. You file an affidavit of service.
I will do that, my lord.
Because we are fixing a short date. In the regular mode, it cannot be sent. On the next date, the appellant may file the affidavit of service.
Maybe she can serve the learned counsel for the defendant also.
If you want, you can serve the learned counsel who has appeared.
I will do that, my lord.
The counsel for respondent who had appeared before the trial court may also be served.
17 March. Number 5 in BS.
And I
Last occasion, my lords directed Tajina to appear before the court.
Assistant Commissioner is present. Lord, an affidavit is filed.
Just a minute. Yes.
Lord, an affidavit is filed on 5/3/2022 explaining, in fact, a transfer petition is filed before Honorable Apex Court on 5/1/2022, my lord. Diary number 956 of 2022, that is also stated in the affidavit of the Assistant Commissioner. For a miscommunication, yes, sought for unconditional apology in the affidavit.
What miscommunication?
But initially, the Assistant Commissioner was the competent authority, my lord. Subsequently, a special officer was appointed. Special officer appeared before through VC before the court and made submission. The records from the Assistant Commissioner office were already transferred to the special officer, my lord. Subsequently, there was a GO by the government to file a petition before the Honorable Apex Court, my lord. There was a confusion in between with regard to whether to file a special leave petition or a transfer petition. Subsequently, a corrigendum was also issued, my lord. After which, on 5/1/2022, a transfer petition is filed before the Apex Court.
Transfer petition against this matter?
Not this matter, my lord. Criminal, it is a scam where Orissa, Telangana, Andhra Pradesh and Karnataka are the places where criminal cases are filed, my lord. To be tried in one court, my lord, before one state.
How it affects the present case?
My lord, in the present case, so far as the properties which are situated in Karnataka, the Telangana High Court has attached few properties, my lord. That was the statement made on 6/7/2021 before the Honorable Court, and that is why the learned government advocate also made a submission before the court stating that they are moving the Honorable Apex Court. Now, a transfer petition is filed, it is pending, my lord.
That has been done only in January 2022. But you had been telling the court
Please.
that matter is pending before the Apex Court much before that.
My lord, from 6/7/2021 it is being told, my lord. First date was on 6/7/2021. On that day, before the Honorable Court, a statement was made stating that there is already a GO.
So there was no case pending before Apex Court at that time.
As on that day, only it is filed on 5/1/22, my lord. The in between, my lord, the GO.
In between, the case was listed thrice.
Please.
And every time it was informed that no matter is pending before the Supreme Court, therefore it may be adjourned.
Lord, apologies on the part of.
Apologies will not do anything. We will hold him responsible for misleading the court and giving wrong information, and therefore he is guilty of committing contempt, and we will send him to jail.
One submission, my lord. There was a government order on 7/8/2021. On that premise, there was a government, my lord, page 19, my lord.
Page 19 of your
The affidavit, my lord.
Proceedings of the Government of Karnataka.
Please, my lord, on 7/8/2021, there is a GO to file a petition before the Supreme Court, my lord. Subsequently, on 21/9, page 21, there was a corrigendum issued. Between
All this shows that how lightly you take the High Court.
Our apologies, my lord.
You
In
have,
fact, that on the
and
last date of hearing, at least we were supposed to
he is only not responsible. You are also responsible.
certainly, my lord, certainly. Because on the last date of hearing, I was supposed to verify the records and make submission before the court. That it was filed at least on 5/1/22. There, our apologies, my lord. This special case number 50 of 2018 was
Assistant Commissioner, किस rank का?
It's usually KS. Mistake is the comment address.
Yes, what is the name of the officer?
not seen.
Do you understand what you have done? Hmm? For this, you can even lose your job. Hmm? You take the High Court so lightly that you give any information what you thought necessary without verifying it, without even finding out as to whether any case has been filed before the apex court or not. You told the additional advocate, government advocate, that case has been filed in the Supreme Court. It is pending. And not once, 4 times. 4 times continuously it happened. And now we come to know that no such case was filed, only a transfer application has been moved, that too in January 2022. And only diary number has been given, that has not come up before the court even. So that cannot be taken cognizance of. How much service you have put in? 14 years. This is the way you have been working now. Hmm? Even Manjunath C, Assistant Commissioner Ram Nagra, is present before the court. An affidavit dated 5th of March, 4th of March, कब का है? Affidavit has been sworn on when? 4th of March. 4th of March has been filed by him. As per the said affidavit. Due to appointment of a special officer to by order dated 29th of April 2022 under Karnataka Protection of Interest of Depositors Act 2004. The files, necessary files, etc., were handed over to him, and he had been pursuing the matter. The state government, by order dated 7/8/2021, had authorized advocate on record for the state of Karnataka to prefer an application before Apex Court. And as such, he was under an impression that the case has been filed before the Apex Court, and as such bona fidely informed the learned additional government advocate regarding the pendency of the case before the Supreme Court. He had no intention to mislead the court, and he tenders unconditional apology for the mistake committed by him, and it is stated that he would be careful in future. Learned additional government advocate informs that a transfer petition has been filed by the state of Karnataka before the Apex Court on 5/1/2022, to which a diary number has been given. Full stop. We have considered the submissions. In view of the explanation given by Mr. Manjunath, Assistant Commissioner Ram Nagra, we do not feel it necessary to proceed any further. However, it is observed that Mr. Manjunath, the Assistant Commissioner, shall be issued a warning, and he shall be more careful in future. List the case. Give a date in June.
Number 6, B.S. Nagar.
we filed a compliance report stating that 20 guntas of the land, which this is disposed of a writ petition where has directed us to clear the 20 guntas of the encroached land of the private respondent. That is cleared now, Now it is cleared, and affidavit is filed. My learned friend has filed objecting, stating that some of the trees are not felled. Because unnecessary trees, which is beyond 20 guntas, we need not fell. May kindly take my affidavit along with the photograph. Clearly, shows that the land has been, which has been encroached by private respondent, has been cleared. Affidavit, dated filed on 19th February. Disposed of petition, has directed us to file compliance report. We have filed that.
This petition is then disposed of.
Disposed of, disposed of on 7th October 21. My lords have directed us to come.
7th October 21. Now, where is your compliance affidavit?
19th February, my lords, it is filed.
19th of February.
Affidavit is dated 17th February.
Yes.
Filed on 19th February of the jurisdiction Tehsildar. Para 3, my lords, his categorical statement he has made in the affidavit page.
Just a minute.
Sorry.
Remove the encroachment and 20 within a period of 4 weeks. All right. Yes.
I filed objection. Page there are two mechanisms. I get the information from the forest department also. I have given the page 5, the document I have obtained under the Right to Information Act. Your lordship may kindly, before that 7/10/2021 order, may kindly look into me. 7/10/2021 order. It is very clear.
Oh, whatever orders were earlier passed, they merged in the final order, which has been by which the petition was disposed of.
This is the final order 7/10/2021. In page 6, my lord, last portion. In Kannada, ಸುಮಾರು 33 ಅಡಿಗಳ ಅಗಲ 20 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಇರುವ ಜಮೀನನ್ನು ಸಾರ್ವಜನಿಕ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕಾಯ್ದಿರಿಸಲು ರೆವಿನ್ಯೂ ನಕ್ಷೆಯಲ್ಲಿ ಗುರುತಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. That is 33 feet wider and 20 guntas, to the extent of 20 guntas is to be removed. But according to them, they have requested the forest department. The forest department given the information at document number 1, page 5. Along with, I have produced it along with my statement of objection dated 3/3/2022. It's very clear, the forest department, where they have stated, as per the WP number 327/221, is produced and is seen that the Tahsildar Hunsur Taluk has requested to remove 60 trees, big and small, 1 jackfruit tree, silver trees 103, coconut trees, 6 angular trees, has to remove for the encroachment of public road in survey number 23, 3 acres 20 acres, situated Purnavasaddi, Anugodu Hobbli. Further, the forest officer of Anugodu Tahsildar, Hunsur Taluk, along with the police staff, have jointly removed only 12 trees as shown by the officials of the revenue department. As per the said report, still 114 trees are has to be removed. This is the information obtained from the forest department. And he has filed a false affidavit for jury. This compliance report filed by the state Tahsildar is there. It is clear violation of the orders of this honorable court. And for 20 guntas, it must be then 660 feet length it has to come. And 33 feet width is to become. But they have removed only 20 guntas, 20 feet in width and 594 feet in length. It comes to 12 guntas.
Now they have filed the compliance. If you feel that they have not complied and given a false affidavit, you initiate the contempt proceeding against the authorities.
compliance means, my lord, the 20 guntas is to be removed. And he is not removed the 20 guntas, only 12 guntas.
In a decided matter where the court had issued certain direction and asked for a compliance report. Now compliance has been filed. If you still feel that that compliance is wrong or the direction issued has not been complied, then the appropriate remedy is contempt. This court is now ceased, no more can consider anything in this matter because matter is stand disposed of. In a decided matter, we cannot reopen and start.
May I make one submission, my lords? Disposed of, if my learned friend permits, my lords, he is a Jilla Panchayat member. My lords, person who is encroached, he was an unauthorized occupant. He has filed application for regularization. When it was pending, we have brought to the notice of the court. Court has said that independently you consider that application whenever he grants, but he cannot encroach this land. For that reason, 20 guntas we have removed. It is a personal interest matter, my lords. I am not, but despite court has said that, my lords, you clear the encroachment. It is there.
We cannot go in all that. No,
We cannot go to this extent, my lords.
if you feel that they have filed a wrong compliance, then you initiate contempt proceedings.
So I filed application for initiate suo contempt.
No, not here, not here. That would be before the appropriate court.
With liberty.
No liberty. We will not say anything. We will say you may take appropriate legal recourse as may be available to you under law. Heard? The learned AG informs that compliance affidavit dated such and such has been filed, which is on record. Para. The court by judgment and order dated
7/10/21.
7/21 had disposed of the writ petition with the direction to respond number 3 and 4 to remove the encroachment in 20 guntas in survey 23 within a period of 4 weeks. The respondent 3 and 4 was directed to file the compliance. Full stop. The compliance affidavit has been filed, indicating therein that the directions issued by the court have been complied and the encroachment in 20 guntas in survey number 23 have been removed.
Please.
Full stop.
The extent of 20 guntas.
The learned counsel for the petitioner tries to submit that the compliance affidavit is not correct and in fact they have not complied the court's order. We are of the view that in case the petitioner feels aggrieved due to filing of incorrect compliance affidavit, he may initiate appropriate legal proceedings as permissible under law. However, in a decided case, the court cannot reopen the issues which have already been adjudicated and the court and the matter was and the court while deciding the case had merely called for the compliance affidavit which has been filed on record. The petition stand disposed of.
Number 7.
Respondent.
Presenting the 7th respondent in the case. In the first writ petition.
Please, my lord. I appear on behalf of the petitioner, writ petition number 9803 of 2021. Lord, your lordships have heard this matter before on several occasions. However, the controversy was relating to whether or not the report of the so-called SIT should be filed before the learned magistrate, and whatever objections we have, we make over there. My lord, that your lordship had passed an order And the relevant portion of the order reads as follows. So far as permission to submit the investigation report in relation to crime number 30 is concerned, we are of the prima facie view that once the investigation has been completed.
Where are you reading?
My lord, your
What are you reading?
lordship's order, my lord, just give me a minute. The last order in this matter, give me the date of the order.
Yes.
The last order in this
3rd of
case.
February.
Yes, my lord.
It is 3rd of February, yes.
Yes, my lord. Now, if your lordship turns to the operative part of that order, which is somewhere in the middle of the second page, beginning with the sentence, so far as the permission to submit the investigation report in relation to crime number 30 of 21 is concerned, we are of the prima facie view that once the investigation has been completed and it has been duly accepted and approved by the head of the SIT, there is no reason for us to restrain the respondent number 4 from submitting it before the concerned competent magistrate, as such leaving all questions open for the learned magistrate concerned, including the question of competence and jurisdiction of the investigating agency investigation officer. We permit the respondent number 4 to submit the investigation report in crime number 30 to the Kavan Park Police Station, Bangalore, before the magistrate concerned. Now, my lord, I'll move on. What happened, my lord, was that there was an SLP filed in the Supreme Court of India against this order, because your lordship may recollect that it was my contention that jurisdictional issues have to be resided.
All right. What happened? What happened?
Yes, by an order dated 18/2/2022. The Honorable Supreme Court of India, my lord, passed an order which says no action shall be taken on the report, and that this Honorable Court may list and hear the matter on 9/3, which was yesterday, my lord. So we were, and then this Honorable Court has been decided to decide the matter on the said date. Now, my lord, we were expecting the matter to be listed yesterday, but it has been listed today. Therefore, my lord, I appear before you today to address you on the question of jurisdiction of this SIT to conduct the investigation at all, before, my lord, any closure report can be presented under section 173 to the learned magistrate. That is the position today, my lord. So, my lord, I'm ready and ready with my arguments, my lord. And I beg your permission to proceed with the arguments that the SIT has no jurisdiction. Now, my lord, my very first submission to you, to your lordships, is that no authority has the power to appoint an SIT save and except a court of competent jurisdiction under Article 226 or under Article 32 of the Constitution of India. Now, my lord, the big question before you is who constituted this SIT and under what authority of law? That, my lord, is the question which I will attempt to answer. And I will submit, my lord, that whoever it be who appointed this SIT had no power to appoint an SIT at all.
Just a minute, just for our clarification.
Yes,
these are three petitions.
Yes, my lord.
Connected.
Yes, my lord. Yes.
3 petitions.
Yes.
This 6586.
Yep.
And this 6586.
Yes.
Of 21.
Yes.
This is a PIL.
It is, my lord. It is a PIL.
PIL. And the other 9803.
It's by the victim, my lord.
By the victim.
Yes, my lord.
And what about 10074?
My lord, if your lordship gives me a moment, I will tell you. Yes, it is also filed by the victim, my lord. She is asking to quash the FIR filed by the respondent, which is an FIR against calling for an investigation into the creation of videos.
Now this PIL.
Yes.
has been filed for the same purpose for which the victim has filed the other petition.
I believe so, my lord, though I cannot say with certainty, but my lord,
You
definitely.
appear for the victim. You appear for the other petitioner, victim.
My lord, I am appearing for the victim, but I had filed an intervention application in the PIL also, which was allowed. But yes, the issues, my lord, are going to overlap. It is true, my lord. It is the prayers in the PIL. If your lordship turns to page 21, issue a writ of certiorari quashing the order passed by the second respondent commissioner of police, dated 11/3, forming a special
Madam,
division.
Madam, you are not audible, madam, properly.
I'm sorry, my lord. Is it better now?
Yes. Yes.
Yes, my lord. My lord, the prayer in that PIL does overlap with the prayer in the petition filed by the victim, in as much as both of us are asking for quashing the order purporting to appoint an SIT. To that extent, there was an overlap, and that is why I filed an intervention which was allowed in the PIL. But my lord, I have an independent petition that is 98.
What we feel
Yes.
that there is no purpose of this PIL when the victim herself has filed the petition.
Perhaps,
So,
because the prayers are overlapping.
that is the main petition of the victim, where she has challenged the constitution of the SIT and
Yes.
that government order.
Yes, my lord, that PIL.
Let that petition,
My lord,
let that petition be heard by the roster court, roster bench, and
Not 9803 of 2021, your lordship is suggesting that to be heard by the roster court.
yes.
Yeah.
We will not dismiss this PIL also. Let
Yes.
it go along with that.
Yes.
But it will go before the roster court.
Very well, my lord, but I was told that this petition 9803 was actually transferred to the DB. But my lord, I have no objection to the matter being heard by the roster court as your lordship pleases. We don't have any choice, my lord, in the matter. Your lordship may decide to send it to the roster court. We are ready and willing to address the judge.
Yes. Heard.
The Supreme Court Lord has said that no action be taken on the report, so there is some urgency, Lord, for
9803 filed by the victim is before is a single judge matter.
And the other?
The other one, both the petition.
But that, but may I make one submission that that public interest litigation, but as per the roster, what comes up before your lordships only.
No, we will. Then we will dispose of this,
and
saying that already the victim has approached this court.
Very
No
and send those matters to the
There's only one
and it will now both these petitions would be listed before the
roster judge.
My lord, I only ask for one indulgence, my lord. There are certain documents which have been filed in the PIL. We might want to refer to them. So only for the purpose of reference, either we refer to them or give us permission to refile them.
Who appear for the petitioner in this PIL?
Mr. Mohan, J.R. Mohan.
J.R. Mohan, appear for petitioner.
Mr. J.R. Mohan, what we feel that already victim has filed 2 petitions which are there, which are connected with this PIL. So there is no purpose of this PIL as such. Already victim is there, that the same prayer, same order is under challenge. So let that be decided by the roster court, roster bench, and this may stand disposed of, this petition, for the purpose of reference of the documents which have been filed in the PIL. Let this petition remain attached.
That's what it remains attached. If anything is there, I will assist this court.
Assist the
because
court.
I have produced certain citations. Earlier when this petition was filed, victim was not before the court.
We will pass the order with the consent of parties.
Yes, because some input may be taken up. That's what my submission.
Heard Mr. J.R. Mohan.
Yes,
10004.
In writ petition number 6586 of 2021, as well as Mrs. Indra Jaising, learned senior advocate in writ petition, the other connected matters, both. For the petitioner, learned
I am also
Advocate
appearing for the
General,
victim.
Advocate General for the state,
State.
and Mr.
And I am appearing for the SIT.
I am
Mr.
appearing for the
Ashok.
victim also, Lord. I am also in the other matter for the victim.
Note down the name. Give, Note down the name of counsels who are appearing, as well as Mr. Ashok, such and such, for the respondent number.
7.
Full stop. The public interest litigation 6586 of 2021 was the first petition filed on the issues involved. Subsequently, the victim has herself
Two victims.
That statement of objections
Same
was filed
victim.
in this matter.
has approached the court by filing the subsequent writ petitions, that is so and so. The order under challenge in PIL is also under challenge in the subsequent writ petitions.
But probably that
There
is
is a-
correct, my lords. Would your lordship permit me to make a submission? I am for the second respondent in WP 10074 of 2021. In that writ petition, what has been sought for is only quashing of the FIR, nothing more, nothing less. It has to go to the roster bench.
Going to the roster bench, that's what. my-
10074, the only relief they have sought for is a
Probably you
quashing
have
of
joined
My lords are sending to the roster
I am the
bench.
complainant.
No, that is the suggestion which fell from the court.
Probably you have joined afterwards, so you are not aware what order we are passing.
No, I thought I should not disturb your lordship
There
during the
is a
dictation of the order. I
consensus
am
between the
here.
parties that once the victim herself has approached the court challenging the order which is under challenge in the PIL, there is no purpose of keeping the PIL alive. As such, the public interest litigation such and such is disposed of. How it is made clear that the remaining two petitions which are connected with the PIL shall be listed before the regular roster bench for disposal. The PIL such and such shall be attached with the remaining two petitions for the purpose of referring to any document if required. The counsel appearing for the petitioner in PIL is permitted to assist the court.
But your lordship may also.
Statement of objection, everything is filed in this main matter also. Respondents have filed the statement of objection.
Whatever it is.
So that it should be.
List before the regular court.
My lord, your lordship may kindly note that pending the final hearing, the proceedings before the learned magistrate have been stayed because the Supreme Court has said no further action will be taken thereof. I just want to reiterate that and draw your attention to that. So if my lord could clarify that, it would be very helpful.
Order is there. The apex court order is already there.
Yes, my lord, but it must be clearly understood and accepted between us and the respondents. That's all. I'm not asking for anything more. My lord, there's no point in facing a proceeding over there and being told that let's proceed with the matter.
Because last night they served us with the report also, the closure report, which was not given till now.
So your lordship may just clarify that all further proceedings
Alright,
before the magistrate are stayed.
in the beginning, you write down, Mrs. Indra Jaising informs that against the order dated such and such, a specially petition number such and such was filed, wherein the Honorable Supreme Court has provided that the report, police report shall not be given effect to
No, my
No
lords,
action
no
be taken.
action
No
be
action
taken.
be taken on the report.
Not
No
be acted
action.
upon. No action
No
will be
action shall
taken
be
on the
taken
report.
on the police report, and the request has been made to High Court to decide the matter finally. The operative portion of the order such and such passed in SLP such and such is reproduced for convenience.
Resealed covers.
Whatever, it will go like this only.
Would your lordship be giving some date in the matter?
Monday.
Monday. Very
It
good.
will be listed on Monday, next Monday.
Obliged, deeply obliged.
Lovely.
Number 8.
The first matter, the main matter is the second matter. I appear for the respondents in the second matter.
Yes,
I will to appear for the appellants in the second matter.
in the second matter.
Please.
Who appears for the first matter?
Yes, I appear for the appellant in the first matter. There is a modification by the district judge in the award. My Leonard has challenged the main matter. The second matter is the main matter.
Okay. And what for you have filed the appeal?
There is a modification that the district judge has said that the payment to the bank should be paid from the date of the claim petition. It should be equally, my lords. That is what I have challenged. It should be equal.
Yes, give the second file.
Second file, amendment of cost rate is not done.
Some amendment was required.
Of the disease of Palanca.
You were required to amend. Honorary Counsel for Appellant submit that appellant number 3 died on 13/7/2021.
Amended and amended appeal memo is also.
Accordingly, it's time to bring LRs on this is a plain on record. When?
29th November. We have filed amended appeal memo also.
Amendment is not done in the
Physical amendment has not been done in the file.
Amended appeal.
Counsel for the appellant. Then write in the connected matter. Counsel for the appellant, press for is allowed. 3 days time, no, 1 week time to carry out the necessary physical amendment in the body of the appeal. List, give a date of.
Lord sir, I have filed a vacating stay application. Pursuant to the award, we are both of us had to pay 50 lakhs each. 1 crore is the total sum contributed. I have deposited the 50 lakhs and initiated execution proceedings. It was at the stage of executing the document by the district judge. Now the stay was granted and the court said vacating stay you filed.
We'll consider on the next date.
28/3.
You do it in the office.
Please.
28/3.
You have to do it with the red pen.
Number 9. Gautam AR.
Respondents 1 to 4 men.
Also file the amended copy.
Amended copy we have filed.
All right.
Only the appeal memo we have not.
Yes, we had requested both of you to go for amicable. Then we'll refer the matter for adjudication.
Lordship may say within 30 days.
But it will depend on you people.
30 days is good enough, man.
Well, all right, all right. Or this commercial appeal has been filed what is the order and the challenge?
21 to 97 applications have been rejected by subtenants.
17th December, impugned order is 17th December.
7, 8.
Challenging the order dated such and such, passed under Order 21, Rule 97, CPC, and in bracket, IA number, take down from the operative portion of the order.
Common.
Filed under section 47, read with Order 21, Rule 97, CPC, and under Order 21, Rule 29, read with Section 151 CPC, in bracket, IA number such and such. Full stop. Considering the arguments advanced by the counsel for the appellant, as well as the senior advocate, give the name, appearing for contesting respondent, such and such, we prima facie find that the dispute between the parties can be amicably settled by way of mediation and conciliation. We therefore feel it appropriate to give an opportunity to the parties to enter into mediation before the mediation center, Bangalore
Mediation Center.
Bangalore Mediation Center. Full stop. The case is referred. The case is referred to the Bangalore Mediation Center. The competent mediator. You need one mediator or two mediators?
One is.
There are only one mediator appointed.
One a competent mediator. No, the two can also be appointed, like in the arbitration. With a competent mediator who is competent to deal with commercial disputes shall be appointed to mediate between the parties. The matter shall be listed on, today is what date?
Today is 10th.
We'll fix a date after 1 week or 15th.
15th.
15th is what date? Day? Tuesday. 15th. On that at 11 p.m. the parties to the case shall appear before the Bangalore Mediation Center. Full stop. Before this, in the beginning, inform that so and so appearing for the appellant as well as so and so appearing senior advocate appearing for the respondent informs the court that they have sought instructions from their client, and they are ready for mediation.
One submission,
The case, the outcome of the mediation in the mediation report, in the form of a mediation report, shall be placed before the court on the next date. Give a date after 6 weeks. 6 weeks.
That is the last working day.
Make after vacation.
After vacation.
26/5.
May I make one submission?
These are two appeals, both of them.
Both the appeals.
Both the appeals.
May I make a submission?
Yes.
Lordship said the first appearance on the 15th. My learned colleague says that he has some difficulty on that day. Can it be on the 16th?
16th, make it 16th.
Very well.
My lord, I appear on behalf of the appellant, my lord. My lord, an award passed by the learned arbitrator, my lord, a recent award giving several directions has now been set aside, my lord, in proceedings under section 34. And the principal grievance, my lord, I make is that the order passed by the learned commercial court, my lord, under section 34 reads, my lord, like a order in an appeal under section 96 of the CPC. In fact, my lord, the commercial court has appreciated evidence and come to a finding that the award must be set aside.
I have just entered appearance day before yesterday. I filed my counter to this IA. They are seeking for temporary injunction for the first time. I would like to file my counter. Lord, maybe 1 week's time will be granted.
My lord, I have no objection, my lord, to the time being granted. But in the meantime, my lord, let status quo be maintained so that they also don't deal with the property. I also will not deal with the property.
Lord, for the last almost 2 decades, I have not done anything. Lord. How can they
Well,
say?
let undertaking be given that nothing will be done. That's all.
Either you give the undertaking or we say that status quo may be maintained.
Status quo may be maintained.
Grateful.
All right. Third, so and so has put in appearance on behalf of the respondents, considering the list, he prays for is allowed a week's time to file objections to the interim relief. Considering the submissions made by learned senior advocate appearing for the appellant as well as the counsel for the respondent, it is hereby provided that a status quo as existing today between the parties shall be maintained till next date of listing.
Both the parties.
Between the parties, the list, give a date after 10 days.
24/5. 24/3. Number 11.
For respondent 6 and 7.
Who appear for appellant? The petitioner.
Ian Raghupati. Sir, Raghupati, please unmute your mic, sir. Raghupati, sir, please unmute your mic, sir.
Sorry, I'm sorry. I'm sorry for the delay. In this case, the government was directed to file objection statement to the main writ petition on the last occasion, and a complaints report is an affidavit stated as complaints report, a statement filed as complaints report has been filed.
Yes.
The main issue is whether
You wanted to file objection to the compliance affidavit.
No, I'm not filing objections.
No, on the last day, time was granted to you to file objection to the compliance report.
I need 1 week's time. Sorry.
We'll grant you further time.
Mr.
Mr. Raghupati, senior counsel for the petitioner, pays for the allowed. How much time? 1 week?
2 weeks.
2 weeks further time to file the objections to the compliance report. List thereof.
In the meantime, my lords, I would request for a copy. I have not been served with the compliance report.
Give compliance.
Now itself. 5-4. Great.
Number 12.
Lord, I beg to appear on behalf. Lord, I beg to appear on behalf of the petitioner's counsel.
Yes.
Lord, may I request for a short accommodation in this matter, Lord? A week's accommodation, Lord.
What is the matter?
Lord,
PIL?
PIL, Lord.
My lords, appearing for respondent number 1 year, my lords.
What is the order under challenge?
Lord, the order and Lord, may I request for a week's accommodation, Lord? Not completely ready in this matter.
Petitioner wants a short accommodation on his request. Case is that give a date in June.
Oh, bless.
Much of it.
We have completed the Rural Bangalore Mahanagar matter relates to management of solid waste management in this particular area, Milor. But BBMP has now filed a memo saying this particular area does not come within their jurisdiction upon their survey. My learned friend informs me it comes within the area of Hebbagudi Town Municipal Council. That's in the.
You will have to implead.
Yes. Now I'll have to.
Learned Mr. Srinidhi, counsel appearing for the respondent informs. Respondent number 2.
Yes, my lords.
Informs that the area, what is the name?
Hebbagodi Town Municipal Council.
Falls within the jurisdiction.
Area comes under such and such. Full stop. The learned senior advocate appearing for the petitioner wants time to move appropriate application to implead the necessary party. I can give a date after 3 weeks.
5-4.
Obliged.
Number 14.
14, the petitioner's matter relates to the levy of forest development fee. My lords, the issue, my lords, is covered by the division bench judgment of this honorable court. Matters are pending before the honorable Supreme Court in appeals filed by the state government. There is a stay of only refund. So refund, my lords, of course, we can't ask because there is anyway, though it's a different angle. But pending that, my lords, what we find is, in spite of the levy being struck down by this honorable court, the respondent authorities keep charging the levy. When they can't charge, that has to be clarified. Because that's why we keep filing writ petitions, because when the auction takes place, they levy the forest development tax or the forest development. But in the first matter, there is an order.
Yes.
Lords, in this matter, Lords, AAG Danjanappa has appeared, and today he has some internet not come. And hence, a short accommodation. In addition to that, Lord, the matter, the SLPs are coming up before Supreme Court on 24/3. Hence, a short
What is
accommodation.
the legal position that till the SLP is considered and decided, the whatever has been decided by this court is to be followed or not?
Yes, my Lord.
Huh?
May I seek a
is to make it a short accommodation.
Mere pendency of SLP would not confer you any right to charge. When the section 98A was struck down by this court, against that only this LP has been filed, which is pending. So
only the refund stayed, but now they are again. Here there is an interim order.
the interim order, no? But
There is an interim order.
Pending matter, remaining connected matter, he says there is no interim order.
Time and again it's happening. Instead of rushing to the court, when notices are issued, the DC or the lower level officer says,
For that only we had called him. He said he will seek instruction. They should in fact themselves clarify. When? Monday?
Next week we will have.
A short accommodation has been sought by the AGA. It is informed that Additional Advocate General, Additional Advocate General would appear in the matter. He is on his legs in some other matter. Next week we'll have.
17.
Please.
Connected matters, there are office objections.
There are some office objection in the connected matters. Please ensure that they are.
15.
I appeal for the petitioners, my lord. My lord, this is a matter where we've challenged the virus of Section 8A2B of the Mines and Minerals Regulation Act, as well as Article 30, Clause 3 of the Karnataka Stamp Act, your lordship. The respondents had sought for time to file objections on the last date of hearing.
Filed a statement of objection.
No, they have not served the copy. And last occasion, I have requested my lord.
My lord, this is the third time that we've made the submission that we've already served learned counsel for the appearing for the government. And in fact, we've also filed memos of service. And on the last occasion, this court had in fact told the government counsel to please verify their records before making such submissions. The memo of service is also placed before your lordship.
The cause list reflects not that they have filed an IA for the amendment also.
Yes, my lord, and we have the acknowledgement for having served the government with regard to the IA also, my lord.
Give one copy extra to him.
Oblige, my lord.
So that at least the proceedings may proceed further.
Yes, my lord. In fact, this is the fifth time they're making the same submission despite having served them, my lord.
And you are also insisting that you have already served and you are
Yes,
not
my lord.
providing another copy.
Yes.
What to do?
I'll serve a copy of the IA, my lord, but the petition has been served almost thrice over, my lord.
Give one more copy to your friend.
Oblige, my lord.
Yes. The net counsel for the petitioner undertakes to provide one complete set, two copies of complete set of writ petitions to the learned AGA.
Since the central enactment is challenged.
Within?
My lord, we'll serve it within this week, my lord.
Within 3 days.
Oblige.
The learned AGA may thereafter file the statement of objection as directed earlier.
My lord, if I may make one submission.
Yes.
It may be recorded that we'll be serving it once again, my lord, because this is the fourth time now, my lord. It shouldn't be seen that taken as being my fault, my lord.
The counsel for petitioner submits that already we have served the copy of the writ petitions to the respondents. However, he undertakes.
The central government, Lord, has to respond, Lord, since
Central government is not here.
They haven't been appearing now for the third time again, my lord.
We received a copy of that.
Already considered.
Granted the license
on 9/2/2022.
9/2/2022, and as such, the writ petition has become infructuous. The writ petition is accordingly dismissed as infructuous.
Number 17.
For the respondent. This matter, a notification about that Annexure D was issued calling for 2 process service minutes. One was reserved for 2A rural quota. Another, my lords, was for physically disabled. Your lordships get to page 49. Portion, my lords, translated, your lordships gets it at page 55. See number 3.
Just a minute. What has been done by Learned Single Judge? What has been done by Learned Single Judge? Single Judge, what has done?
Learned Single Judge, my lords, has said that though he is not physically, he is not of low vision, he is hearing impaired. So the Learned Single Judge says even if he is hearing impaired, we have to give him the
Employment.
We have to take him as a processor.
A careful reading of a portion. Please come to paragraph 9. Paragraph 9 of the order impugned.
Of the above petition, government order makes it clear that a physically handicapped candidate belonging to a particular disability, which is reserved under the notification is not available, the said post reserved for physically handicapped could be filled up by a candidate who suffers from any other physical disability. The said government order was in force as on the date of notification dated 30/10/2013, inviting applications to fill up the post of processor. The circular dated 19/2/2018, which is relayed on by the respondent, has come into force subsequently, and the reading of the circular dated 19/2/2018 makes it clear that it is made applicable prospectively, stating that the instruction shall be taken note of by notifying the vacancies in future. Thus, the respondents committed grave error in not considering the candidature of the petitioner for the post of process server under GMPH. For the reasons
No, he doesn't belong to that category of physically handicapped which was advertised.
which was advertised.
Now,
Low vision.
all right,
Because we
now
have-
the London Single Judge has come to conclusion that in case that particular category is not available, then the post can be filled up from the other category of the physically handicapped.
Please.
Now, on what basis he has come to conclusion?
On the basis of the government circular, which was produced at Annexure K, my lords, page 91. He had extracted the relevant portion of page 91. The relevant portion, my lords, translated in page 96.
94.
96. In direct recruitment to Group C and Group D posts in state civil services, out of 5% reservation fixed, 2% reservation is ordered to be reserved for blindness or low vision, 1% each for hearing impairment.
Page 94 is the government order.
96. That is the government order relayed upon by the petitioner, the respondent hearings, which is extracted by the Learned Single Judge. The order portion is extracted at page 11.
Out of 5% reservation fixed, 2% reservation is ordered to be reserved for blindness or low vision. 1% each for hearing impairment, locomotor disabled and persons. Yes.
In order to enforce reservation as per order dated so and so, fixing 20 points roster for 100 vacant posts, it is directed that points 424 is to be reserved for blindness or low vision, 44th for hearing impairment, 64th for locomotor disability, and 84th point for persons who have recovered from leprosy so and so. And if the handicapped persons designated against these points are not available, it is directed that other handicapped persons are to be considered.
Now, the respondent belongs to which category?
Hearing impairment, which was not notified in Annexure B, page 55, my lord, was the notification. When we call for low
Yes, what do you say?
Well, there is a government order. If there is no availability of the particular.
This is what she is showing. This is 1st of August 2009. This is the government order, but here certain categories of handicapped were notified. And it was said that in case any of this category person is not available, then the person from other category which are not notified can be considered. But the persons of hearing impairment have been mentioned in that.
No, I have
the post was advertised only for the low vision.
Low vision.
So a person of hearing impairment cannot be considered.
No, my lord, there is a government order in the 2013. If there is any particular category of the.
Which government order can you show?
That is what, my lord, this is the order produced at page 94. And culminated in the order at page 27 of the appeal memo in Kannada portion on page 11, 27.
Come to the translated copy on page 97.
Where does category 2A say low vision? Where do you get it?
Category 2A, my lord, it is general category. Page
No, where do you say, where do you get physically impaired only is restricted only to
55, page 55.
55.
Yes. The Kannada portion is at 50. Drushti Mandya
ನಿಮ್ಮ English translation
the asterisk at low vision. After the processor, the 2 points.
general candidate.
Cannot change the category.
Yes, my lords, below low vision. It was reserved for low vision alone. The government order, my lords, does not state in the same notification we have to consider. Pursuant to this, my lords, we have issued another notification, which is at page 40.
No, page 55, annexure B.
Yes,
Is there a reference to page 16?
Does not disclose this.
No, annexure A is there.
Not annexure B, my lords. Annexure B is the notification.
It is not with respect to low vision.
A fresh notification, my lords, page 47, your lordships get. Here we have considered this as a backlog post. And when we see page 47, 21 posts were there. One post we have considered it as backlog post. The above post is reserved for low vision candidates. If low vision candidates are not available,
You find your objection. We will stay
I
this.
filed my objection to the stay application.
No,
Petition I have not
they are
filed.
fine.
I have filed my objection to the.
We will have to stay this order.
My lord, because my lord is already aged persons, disabled persons. There is a government order in 2013. If there is particular disability is not available.
2018, even backlog post.
This notification, after nobody qualified for the post, we issued this
Would
notification.
he be eligible as per annexure A?
Yes, he's eligible as per annexure. He's eligible.
Then what remains to be answered in this writ appeal?
He challenged Annexure A itself, stating that he's time barred as an Annexure.
Annexure
Age
A,
bar.
Madam, I'm 2000.
As per
Annexure A is concerned, I'm but age bar, but I'm qualified in the
earlier one.
Earlier. And he is losing the government job in any way. He can't get any government job at all. And it is the officer of the judiciary who is the appellant, and he has must respect to the orders of the lawyers in the
in 2013 clarified that in case that particular category is not available, then other category person can be considered.
There is a circular, my lords, and I should say there is a government circular. We have relied upon that circular, which says first time when it is notified, it must be for that particular disability. The next time, if there is no candidate, the next time when it is notified, the other persons must be. It must be for the same disability. And in that notification, if there is nobody available, the other disabilities must be considered. That is the circular. Based on that circular, we have issued an Annexure A, calling upon minutes. Here we have said, if low vision is not available, we will go to other disabilities. If other disabilities also are not available, we will consider the general. That's how we have done it. Now, only two things, my lords. We have no Annexure B, we have not notified the other disabled persons. If we choose the petitioner, my lords, the respondent, who was not come under the category of low vision, the other people from other disabilities, my lords, they would not have a chance. So, and section 34 of Right to Persons with Disabilities Act, my lords.
But he is eligible otherwise.
He's not eligible.
Now, in view of your circular.
No, my lords, the circular was also there earlier.
You have yourself said that first time when it is not available, then the other category. So then in other category, he will become eligible.
As per Annexure.
Then only your ground is that since other of this category have not been given opportunity.
And also section 34, my lords, of Right to Persons with Disability Act. 34, my lord, says 1% each must be reserved for that particular category. So if we do not reserve it, my lords, it would be violative of section 34 also. Section 34, my lords.
It is all too technical. How does
section 34, my lords.
Let me consider.
And even my lords, under Annexure A, there could be.
It's only class 4 process server.
Mela?
Class 4 process server.
Processor. Law says, Mela, there could be other physically disabled persons who would challenge this. Appointment stating
what purpose would be served if you will advertise again, give the opportunity to that all the persons of this category?
Now, since
already a person who is available to you.
No, my lord, he is not low vision. He is hearing impaired. Now, there could be other candidates who are hearing impaired also. They lose their opportunity, my lords, to make an application.
Where are those persons?
How do we know, my lords? They do not know, my lords. How do they know that this challenge?
The person who is before you, you are not giving him appointment, and you are waiting for the others to apply. What is the point?
That appointment would also be challenged, might be, my lords.
When it is permissible,
no, my lords,
then we do not find any reason to grant indulgence.
Permissible in the next notification, my lords, not in the same.
Whatever it is.
Not in the same.
You have also provided that in case that particular category is not available, then you will relax.
Kindly see section 34, my lords.
We do not find any reason to grant indulgence. Sorry. What remains? 34 is too technical.
We leave it to your lordship. These are the only 2 grounds we have. Every appropriate government, may I read, my lords?
Yes.
Shall appoint in every government establishment not less than 4% of the total number of vacancies in the cadastre in each group of the posts meant to be filled with persons with benchmark disabilities, of which 1% each shall be reserved for persons with benchmark disabilities under clause A, B, C, and 1% for persons with benchmark disabilities under clauses D and D. So A is blindness, low vision 1%, deaf and hard hearing is 1%, locomotor disability is another. C and D will be another person. Now, my lords, if we give him, we usually take into consideration this 1%. This time, my lords, is for low vision. The next time when we issue a notification, we've already considered a hearing impaired. So how do we calculate that, my lords? These are the only 2 hurdles that we
see the proviso.
Proviso clause provided that if the nature of vacancies is the establishment such that a given category of persons cannot be employed, the vacancies may be interchanged.
Cannot be employed is different, my lords. Here it is not cannot be employed. Here it is the case where we have not notified to other persons with disabilities. It is not cannot be employed.
No. But when he is adopting the 2018 circular, he could have applied for the 2013 notification. 13, it is a prospective. She cannot claim the retrospective effect of 2018 circular. Both circular or circular.
2 issues she's saying. One is if she gives it to you, that itself may be challenged. Secondly, if she gives it to a hearing impaired, subsequent, how do they rotate? That is the issue.
No, rotation. Now she is relying upon the 2018 circular.
We are not relying on any circular as such.
The next time reservation, which category?
Which category is?
Yes, the specific points are given. So which category they give. And here our main grievance is, my lords, the other people do not have the notice of this notification.
That question may not arise because here you are giving it to a person with respect to a person for whom you had sought that is low vision.
Yes,
so since low vision category was not available, therefore you have extended it to the
present notification. In the present,
so
2018.
The reservation will not change. Category, the roster of the reservation would not change. It will be as per that only.
Can we see annexure B, my lords?
So that will not change.
What we can say is that in view of annexure K, without changing the reservation, since hearing impaired is also a benchmark disability, in the absence of visually impaired, we are doing this.
Extended it. That reservation for vision has been extended to this as it was not available. So therefore, it will not change the category for reservation in the subsequent selection.
2013, my lords, we had reserved this for low vision. The other persons who could have applied, who had the hearing impairment, have not applied. Locomotor disabilities, they have not applied. Now, if they...
At any rate, the 2018 supersedes the 2013, does it? Therefore, it's only for 2013 is the notification to be reckoned.
We do not know how many people have applied under 2018 notification, because this was subsequently...
That one, 2018 takes into account visually impaired, as well as in the absence of visually impaired, others can come in.
We do not know, my lords, in 2018, if there was any visually impaired candidate who had applied.
We can say that allowing the petition and granting him the post of the process server under the 2013 impaired notification read with 2009 government circular or order will not affect anybody who has applied under the 2018.
No, 2018, that's the only post. So there cannot be any other post. If we give the post to him, there is no other post.
In 2018.
We do not have any other post. So we do not know how many people had applied under 2018 notification.
I don't find any reason to interfere.
We do not have any other post. This is the only post we treated it as a backlog.
All right. What we find that if you had done it on your own,
yes,
then there would have been a difficulty for you. But once we will dismiss the writ appeal, then
if subsequent challenges are made, my lords, it will be a real bad problem for him and
let him have the benefit of the order which he has got in the writ petition. There is too technical. There is no need for interference.
No, my lords, the only technical thing
Equity
is
doesn't demand. Equity doesn't demand interference.
Equity does not demand. Yes, my lords. Low vision, the other candidates also are physically disabled.
This is a court of equity.
Yes, my lords.
We'll dismiss.
Give it to your lordships, but this is the only.
Right. We'll dismiss the appeal.
Okay.
Issue number 18.
If your lordships dismisses the appeal, the time granted to appoint my lords needs to be extended, my lords, because it's already.
Will extend.
They have filed a contempt petition. I don't want them pressing the contempt petition.
Don't press.
I will not press.
That may kindly be extended. We'll appointment, but that may kindly be extended by another month.
8 weeks from 8 October. We'll say 8 weeks from today.
Yes,
but
like.
Number 18.
The petitioner's counsel in this case. In this case, the petitioner had applied for a quarry lease prior to the amendment of the rules in 12.8.16. Now, as my lords would recollect, the rules were amended with effect on 12.8.16. Rule 8B1 was introduced. An endorsement came to be issued. The endorsement was challenged before this honorable court, and on 30th of August 2018, if my lords were to see page 31, this honorable court set aside the endorsement and directed the authorities to reconsider. After receiving the report, that is important. Subsequently, my lords, a conditional grant notification was issued in my favor on 27th of June 2019. The matter stood there. Since the government was not moving with the matter, we were constrained to file a contempt petition. CCC number 560 of 2020. Now, while the contempt petition was pending, a final grant notification was issued, my lords, on 8th of February 2021, which my lords will find at page 39. Now, my lords, all of this water has flown under the bridge. All that is required is, as the Honorable Supreme Court said, the ministerial act of executing the decree. Now, my lords, the impugned order is passed, which my lords will find at Annexure A. Setting the clock back, relying on the judgment in Thirumalesh's case, and saying that we cannot consider application because it is barred under Rule 8B1. Now, I ask myself two questions. One, what is the sanctity of the order passed by the coordinate bench in 2018, subsequent to which a conditional grant notification was issued? The second question I asked myself is, my lords, when a contempt was filed, a final grant notification was issued on the basis of which the contempt was closed. Now that contempt is closed, now once again they've set the clock back, my lords. Now I'm conscious of the fact that there is possibly, my lords, since it is an order, there might be a revision and so on. But why I would urge my lords to hear this case is, this is not a stray case.
When you are conscious, then why you have come here? That is
there are several such cases, my lords. There are several such cases where this honorable court has directed them to consider after receiving the reports. Now, my lords, those orders attain finality. They have not been challenged. They have attained finality. Of course, after that, my lords, Thirumalesh's judgment upheld the validity of Rule 8B1 and laid down the law with an element of finality. But the question, my lord, that may arise is, what happens to those orders prior to Thirumalesh, prior to 16th of August 2019? The government may have to take a definite stand, my lord, because this will not affect only the petitioner, but hundreds of other such quarry lease applicants whose applications were, if I may say, deemed to be saved by the orders of this honorable court. Therefore, my lords, my only request is, let the government file its affidavit stating its stand on record.
Without affidavit, the stand is very clear.
Without
now he has not opened the mouth also, but
he
can see his face and read that he is going to say that revision.
Revision lies. No, I'm completely conscious of the fact also.
But why I would urge my lords to consider this case, and because my lords, this may not be the only stray case, and this will not be the only stray case, and some finality.
No, in every case they'll say the same thing. They're not going to say anything different, isn't it?
If it goes to the revisional authority, certainly I will end up in this court only 3 months later.
Right.
Yes, what do you say?
And since it's not a saved application, the government under 8B to E rejected the proposal for grant of lease and remanded back to the Deputy Director of Mines for reconsideration. It has been reconsidered in the light of Tirumala's case, and an impugned order came to be passed. It is just and proper. Against which,
if they want to file revision, they may file.
But my only request is that there is an order of this honorable court. Some sanctity will have to be given, my lords. In fact, I go to the extent of saying that, my lords, when
we will not say anything.
Contempt, they'll issue a final notification. That's nothing but, I mean, an abuse of the contempt process also, my lord. They issue a final notification to escape from the clutches of the contempt court. And now, my lords, now that the contempt is closed,
He says that even it has been reconsidered, and Tirumala's case judgment has also been considered, and that since it is not a saved application, therefore it has been rejected.
I'm completely conscious of that, my lords. In fact, I had the benefit of also assisting this honorable court in Tirumala, which is why I'm aware of exactly what transpired. But, my lords, my only submission is this: there are, if I may say so, hundreds of such orders as in this case was on 30th of August 2018. Hundreds of such cases were disposed of by division benches of this honorable court, directing the authorities to reconsider after receiving the reports. Now, my lords, this government consciously chose to accept those orders. Finally, of course, my lords, when the government did take up the issue, Tirumala's judgment came to be passed. But prior to 16th of August 2019, when Tirumala's judgment was rendered, prior to that, my lords, some sanctity will have to be given to those orders. That's my submission. Otherwise, the Tirumala did not and could not have overruled those orders.
This is not the stage. If you want, you may file revision.
My only submission is this: if
Revision,
I file a revision,
let in the revision you take this issue then.
But also, my lords, possibly.
And even in the earlier round,
yes,
page 34.
Yes, ma'am.
It's not as if some right is recognized in your favor.
It was only said.
Of course.
And if you see the notification also,
yes,
all that it says is page 40.
Yes, ma'am.
In compliance with the order, 28 is prior to Tirumala. And in the context.
Page 40?
Page 40.
Clause
K.
Clause K, yes, ma'am.
Right.
Notification is issued in compliance with the order of the Honorable High Court of Karnataka, and it's ordered 28/6/2019 in writ petition number 6483 of 2000.
That was prior to Tirumala. And prior to Tirumala, all that this court said was consider.
Yes.
Because of Tirumala, they have done this.
But the only question now, my lords, is
for us to interfere.
If I may, I completely bow down, my lords. In fact, of course, if my lords would turn back to page 31,
right.
I'll only add to what my lordship or what your lordships just. Right. Not only did the court direct them to reconsider,
right.
but if I may read, accordingly, these writ petitions are disposed of at this stage itself while disapproving the impugned endorsements.
Correct.
Intimated rejection of the application of petitioners with the requirement that the authorities concerned shall send their views, opinions, reports to the authorities of the Mines and Geology Department within 2 weeks from today.
Correct.
So, my lords, the ground on which the earlier endorsement was issued was that the reports have not come.
Right.
Here, my lords, there is a positive direction to send the report.
Right.
And in view of course, this honorable court could not have said grant the mining lease. Right. But this honorable court consciously did say send the reports.
Right.
If the report said there's no objection, then of course it would have to proceed as per the existing law and that prior to 12/8/16, prior to the amendment.
You're saying prior to the law, prior to Tirumala has to be applied.
Yes.
Because this or the report would relate back prior to Tirumala.
Yes, sir. And
how do you say that?
What my lords is saying, this order will have.
In effect, what you are saying is, though it is not a saved application as per the rule or as per Tirumala, it is saved because of this order. That's what you're trying to say.
Which is why I said also, I mean, it is deemed to be saved.
Cannot be, no? That's what. It is deemed to be saved because of this order.
Nothing can be against the rules.
Well, I completely accept without any dimmer, whatever my lords is saying. But on the other hand, if my lords could see what happens on the other hand, there is an order of this honorable court. There is an order of this honorable court to send the report.
No, to send the report only to that extent, right?
Yes, and then decide on the prayer of the writ petitioner for execution of the lease deed.
Right.
So the reports have come.
Right.
Now, my lords, once the reports have come, that means necessarily, my lords.
Did the reports come and a decision taken prior to Tirumalesh or after Tirumalesh?
Reports would have, this order is prior to Tirumalesh, without a doubt.
No.
Reports
come after this
reports
order.
may have come some before, some after. I'm not entirely sure. Reports would have come.
Therefore, if after Tirumalesh, then what do we do? Is there an exit route so far as Tirumalesh is concerned? You will have to look for some exit route.
Then my only question I asked myself, I completely bow down. In fact, my lords asking a very pertinent question. This issue is very important, my lords, simply because otherwise, my lords, this order and then the final notification also issued under the threat of contempt. What happens to that one? There's no sanction to that at all.
That's why we show. That's why we showed page 40, where the final notification is issued only on the threat of contempt and on this order. But this order is superseded by Tirumalesh.
That's where I beg to differ. It's not superseded. Tirumalesh would not have overruled.
Okay, what is the
also a coordinate bench?
What is the effect of Tirumalesh's order on the directions issued in this order? If at all directions are issued,
it would have no effect, in my opinion, because it could not have considered these directions.
That's the argument.
In fact, if I may add what my
we understand the argument now. Tirumalesh is there.
Yes.
Prior to Tirumalesh, there are certain directions which have recognized and created a right in your favor.
That's
depending on the report.
Yes.
The reports have come merely because Tirumalesh subsequently takes a different view, or the Tirumalesh makes your application not a saved application. That would not nullify the right recognized and
under this order. That is in short what my submission is, and also a right that accrues to me by virtue of the grant notification issue.
Your order does not decide any issue. The Tirumalesh has decided certain
That's
issue.
right, of course. And in fact,
and it is a subsequent judgment, it will prevail.
Not only that, these judgments have been considered in Tirumalesh case.
Both ways, the Tirumalesh will prevail.
Only for the fact that it was not a precedent.
It has been considered in Tirumalesh case and held that it is per imperium.
Not overruled. It cannot overrule. A division bench cannot overrule a division bench order.
Not in effect.
In effect, all this is not a precedent to me.
Yes.
Now, what do you want? You want to go for revision, so we will dispose of.
Para 45 of Tirumalesh.
Para 45.
Yes. We'll take our chance before the divisional authority.
Third, this petition has been filed seeking following relief. After arguing the matter at length, learned counsel for the senior advocate appearing for the petitioner makes a statement at the bar that he may be permitted to avail the remedy of revision under Rule 53 minor mineral rules, and the repetition may be dismissed with liberty to avail the said remedy.
One request, but the divisional authority be directed.
The petition is accordingly dismissed as not withdrawn with liberty to petitioner to avail the statutory remedy of filing revision.
Divisional authority in expeditious manner.
In case any such revision is filed within 2 weeks from today, the revisional authority is expected to decide the same expeditiously.
Grateful.
In accordance with law.
Serial number 20 also is identical. 20.
Same order 20.
Grateful.
Number 19.
Had issued notice and granted a meeting order, which also was extended thereafter. Time was taken to file objections.
Anyone
but we have filed a status report.
who has appeared for respondent? GA.
Respondent is
Yes.
But in this.
You file the statement of objection, will consider. Then an AGA press for is allowed 4 weeks time to file a statement of objection. Give a date after 4 weeks. The interim order granted again shall remain operative till next date of listing.
20th, 19th.
20th.
24th.
No, why you are giving date here? Give date afterwards, after holidays. All these matters are to be heard before vacation. It will be difficult to hear that. Give the date afterwards, in June.
7/6.
Interim order shall continue till next day.
21.
Hello. In this matter, we had filed a writ petition for direction to the respondent to release to make payment of the INO which they have sought to auction, my lord. Now, my lord, they have communicated saying that they have rejected our application by communication dated 7th March 2022, my lord. Your Lordship may kindly permit me to withdraw to challenge the rejection, my lord.
And counsel for the petitioner. This petition has been filed seeking following relief. Learned counsel for the petitioner makes a statement at the bar that he may be permitted to withdraw this petition with the liberty to challenge the rejection order.
Rejection is dated, communication is dated 7th March 2022.
7th March 2022.
That it has been rejected on 23rd August 2016. Communication is dated.
Date of the order only.
23rd August 2016.
23/8/2016.
23/8/2000.
That is the
16.
Writ petition is accordingly dismissed with aforesaid liberty.
May I request, there are 3 other petitions which are not listed today, my lord. They are connected. Can I give those case numbers so that similar order may be passed if possible, my lord? Not listed today.
Not listed. You want the same order to be passed.
It is not before us. How can we pass any order?
There is already order to connect the matter, but it was not connected. I'll leave it when the matter is listed. I'll mention, my lord.
We can't help it. When
Please.
it will come, only then we can pass any order.
I'll mention it when it gets listed, my lord.
Yes.
Number 22. Ramaswamy Kotwal.
On number 36.
On
number 36.
26. Yes.
My lord, the petitioner is seeking the quashing of notification pertaining to filling up of in total 56 vacant posts of president members and women members of district consumer redressal forum, which is at annexure B, your lordship. English version of the improved notification is at page number 41, your lordship. Page number 41.
That petition has been connected with this.
Please, your lordship.
That is the CH-6.
Number 41, your lordship.
R36 is Chikballapur district forum. That's not been served still. So we'll have to hear them also.
appointment notifications are issued.
R36 has not been served.
Please, your lordship.
R36 has not been served.
R36, the government advocate may take.
If they are ready
Government-
to accept notice, give them notice.
That is the district consumer forum.
Will you accept notice for
Please,
36?
please.
Give notice to. Learned AGA is ready to accept notice for R36. Copy of the notice may be
for everybody.
Consumer forum. The panel.
I asked you, you said yes.
I'm sorry. I'm sorry. I'm sorry. I'm sorry.
You will have to take fresh steps. Yeah,
Your
report
lordship,
and
by
service.
considering the grave urgency
Just a
report in
minute.
this
What is
matter,
the
your
report?
lordship.
It's not received any, neither power nor payment is received.
We'll have to wait then.
That is very time is lapsing.
Take the steps.
Take the first steps.
As per office report, R36 has not been served. Learned Counsel for petitions shall take fresh steps. The PF shall be filed within 1 week.
Your Lordship, one
Official
submission.
is issued fresh notice
Your
thereafter.
Lordship, by considering the grave urgency involved in this matter, Your Lordship, this honorable court
Yes.
has agreed to dispose the matter finally by today, Your Lordship. Your Lordship, because the appointments order was issued on will be issued on 14th of this month, Your Lordship.
After 3 weeks.
1-6.
Your Lordship, one more submission. In this case, Your Lordship, in the previous order, Your Lordship, that on 6/9/2021, Your Lordship, the whatever the appointment is subject to the outcome of the final order of this honorable court, Your Lordship. That has not mentioned in their appointment order, Your Lordship. Kindly direct the government to include the order of this honorable court in the appointment orders, Your Lordship.
If they are not mentioning, go and file contempt.
ಬರೀಬೇಕಲ್ಲ ಎಲ್ಲ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ
Certainly.
ಎಲ್ಲದನ್ನು ಬರೀತೀರಾ ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಯಾಕೆ ಮತ್ತೆ
Yeah, it has been intimated, my lord. It is intimated.
ensure that all it is inserted.
Sir.
Otherwise,
We cannot direct.
from whatever I know, in all matters,
Moreover, Your Lordship, this matter is squarely covered by the decision of the honorable High Court of Bombay.
about insertion of that
Got it.
interim order of this court to ensure compliance.
That may be noted in the order.
Number 23.
ಮಾಡ್ತಾರೆ ಹೇಳಿದ್ದಾರೆ.
I appear for appellant, my lord.
Yes.
I have filed the additional documents under Article 21 Rule 27, my lord. Earlier, in the last date of hearing, it was filed for filing objections by the respondents.
You are appearing in which matter?
25, my lord.
Number 23 now is
23.
Sorry,
ಏನ್ ಮಾಡಿ
appear for the petition. This challenge in this petition, you know.
For the respondent number 7 in this case, my lordship, this case last occasion of filing color.
Just a beneficiary foundation. What you have challenged?
I am not sir. I have not received the petition copy.
The list of beneficiary, my lord, under the scheme called Rajiv Gandhi Housing Scheme, my lord.
What is there any interim order?
There was an interim order throughout, status quo with regard to the allotment and other things.
There is no interim order operating. The interim order is still operating.
Please.
5/12/2011.
Huh?
5/12/2011. 5th December 2011, my lords.
There is an interim order.
Status quo, I think, also not my file.
May make one submission.
May not survive now.
1/2/2012.
Yes.
Interim order to continue.
Yes. 5th December 2011 is the first order.
Afterwards, interim
Yes.
order to continue. Status quo.
Please.
Allottees are not interested.
Even Millers, it may not be a third respondent, Suman Baliga appears, he has to say Millers, whether they have finalized or not. We have reserved the land given to them.
Correct.
Third respondent has to finalize it, whether they have done it or not.
Last occasion, not the third respondent submitted. Now the scheme has merged with the other schemes, not the Awas Yojana and other things. My submission would be, now the status quo is there. The list which was prepared by the prepared in the earlier scheme, Lord, it was not approved before the Gram Sabha. That is the ground on which we have challenged the list. The fresh list can be published and new scheme can be, Lord,
Madam.
Madam has to say, third respondent. She is the agency.
Admittedly, there is,
CS
as per the scheme,
third respondent. If it is not finalized, kind of priority they can give Millers to the present existing scheme and they can.
as per the
For the Rajiv Gandhi Gramina Vasati Nigama Niyamita. When will senior come, madam?
Why don't postpone it? There is 2011 matter.
She has to take a stance as
They have filed the statement of objection last occasion. That, the respondent number 3.
They have filed.
They have filed the objection.
I don't have a copy.
Yeah, what is their stand? It must be one of the oldest cases in the PIL.
Not they presently, my lord, the new scheme is there. Not fresh scheme, the beneficiary has not been allotted or anything has been done in furtherance of this list. The fresh scheme can be formulated and it can be.
Which is the fresh scheme?
My lord, the Awas Yojana is there. The Pradhan Mantri Awas Yojana is there. Similar scheme earlier.
For that, the persons will have to apply and proceed.
Please, now this which was now the beneficiary which was called which was listed.
We don't think that even if the petition is dismissed, you will able to implement that scheme.
That is third response is to say what is the
There is
stage
no
of
purpose keeping this petition pending.
yes.
There is no purpose of
Absolutely, my lord. My submission would be it can be now it can be disposed of with the direction to fresh scheme. As of now, there is no the layout formed anything.
The fresh scheme, if it is available, then all these beneficiaries may apply and fulfill the procedure prescribed. They would be considered.
Absolutely, absolutely. That is what my.
All right, heard. This public interest litigation was filed in the year 2011. It is one of the oldest cases pending in the PIL jurisdiction. The counsel for petitioner submits that the challenge in the writ petition was made to the list of beneficiaries which was prepared by respondent for extending the benefit of Rajiv Gandhi Gramin Vasati Nigma. Yeah, what was the scheme?
Niyamita. Nigama Niyamita.
Para 3 of the page 16.
Gramina Vasati Nigama Niyamita.
Para 3.
Rajiv Gandhi Gramin Vasati Nigma Niyamita. Niyamita. After full stop. The court wide order dated 5/12/2011 had granted status quo to be maintained as far as allotment is concerned. It is submitted that in view of the interim order, which is operational till date, the respondents have not finalized
number 3.
The beneficiaries, list of beneficiaries for under the said scheme. It is further submitted that now the said scheme is not in existence, and as such, no person can be given the benefit under the said scheme. It would be appropriate that the writ petition is disposed of with the observation that the beneficiaries whose name had been included in the list prepared by the.
They can apply.
We are not saying anything. Who had. What you say? Respondents contained in action number B to the writ petition may apply to the existing schemes such as Pradhan Mantri Awas Yojana, and the respondent may consider their consider them for allotment under the existing scheme. Full stop. The learned AGA and the council for respondent number 3 have no objection to the same. The writ petition is accordingly disposed of with the observation that the persons who were included in the for the benefit of such and such Rajiv Gandhi scheme, they would be at liberty to apply afresh under the existing scheme, if any, maybe Pradhan Mantri Awas Yojana, by completing the formalities, and they may be considered by the respondent in accordance with law.
On submission, Lord, I agree for the Rajiv Gandhi Housing Corporation. Sorry, I was not able to. The housing scheme, the petitioners are claiming that it is still under the existence, but it is name has been changed. Lord. That's all.
Where you have written, no, it is not in existence or has been changed to some other name.
Number 24.
Serial number 24, I appear for the petitioner, Your Lordship. I kindly pray for a short accommodation to bring the legal representatives of the sole petitioner on record.
This does not survive for consideration.
It does not survive, London AGA says.
Because the LRs cannot come on record in a lapsed lease.
Petitioner has died.
Yes.
No substitution has been carried out. When they have died? When died?
That I am not aware.
Are you aware when the petitioner has died?
The petitioner has died on 11/4/2019, Your Lordship.
2019.
Indeed.
Then there is no question. The petition does not survive. You move a application for substitution along with application for recall of order.
I'll file my applications in a week's time, Your Lordship.
Or the petitioner has died on, what is the date?
11/4/2019.
11/4/2019. No substitution of LRs has been carried out till date. As such, the writ petition stand dismissed as abated. Dismissed as abated. Interim order finished and discharged.
I appear for appellant.
Appearing for
Appellant, Your Honor.
respondents counsel.
I have filed the additional documents, Your Honor, under 41 Rule 27.
Who appear for respondent?
I am appearing for the respondent 4 and 5.
Yes, Mr. Rajgopala, you want to file any objection?
Yes, I wanted to, some document he wanted to place it on record. Copy is served on me yesterday. I will
Yes.
file my objections, my lord.
What do you want? You want file objection?
Yes, within 10 days, my lord, I could able to file my objection.
Advocate appearing for respondent, praise for is allowed 2 weeks time to follow objection.
Interim orders will be extended, madam.
Year 2 of 2022. Give a date after 4 weeks.
Interim orders will be extended, madam.
Interim order shall continue till next day.
Much obliged, madam.
Passover?
That eviction matter, State Bank.
Passover matter. Number 2.
Yes.
He has requested me to get an adjournment till Monday or Tuesday. He has not come to the court today.
On the request of counsel for petitioner,
Tuesday.
put up on Tuesday. Just two and three.
In the meanwhile, May Saruji notice.
Two and three.
2 and 3 same.
We are not issuing any notice.
I will get him on that day.